Federalist number 33, the same subject continued, concerning the general power of taxation. From the Daily Advertiser, January 3, 1788. To the People of the State of New York. The residue of the argument against the provisions of the Constitution in respect to taxation is engrafted upon the following clause. The last clause of the 8th section of the first article of the plan under consideration authorizes the National Legislature to make all laws which shall be necessary and proper for carrying into execution the powers by that Constitution vested in the government of the United States, or in any department or officer thereof. And the second clause of the 6th article declares that the Constitution and the laws of the United States made in pursuance thereof, and the treaties made by their authority, shall be the supreme law of the land, anything in the Constitution or laws of any state to the contrary notwithstanding. These two clauses have been the source of much virulent invective and petulant declamation against the proposed Constitution. They have been held up to the people in all exaggerated colors of misrepresentation as the pernicious engines by which the local governments were to be destroyed and their liberties exterminated, as the hideous monster whose devouring jaws would spare neither sex nor age, nor high nor low, nor sacred nor profane. And yet, strange as it may appear, after all this clamor, those who may not have happened to contemplate them in the same light, it may be affirmed with perfect confidence that the constitutional operation of the intended government would be precisely the same if these clauses were entirely obliterated, as if they were repeated in every article. They are only declaratory of a truth which would have resulted by necessary and unavoidable implication from the very first act of constituting a federal government, and vesting it with certain specified powers. This is so clear a proposition that moderation itself can scarcely listen to the railings which have been so copiously vented against this part of the plan, without emotions that disturb its equanimity. What is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? What is a legislative power but a power of making laws? What are the means to execute a legislative power but laws? What is the power of laying and collecting taxes but a legislative power or a power of making laws to lay and collect taxes? What are the proper means of executing such a power but necessary and proper laws? This simple train of inquiry furnishes us at once with a test by which to judge the true nature of the clause complained of. It conducts us to this palpable truth, that a power to lay and collect taxes must be a power to pass all laws necessary and proper for the execution of that power. And what does the unfortunate and culminated provision in question do more than declare the same truth, to wit, that National Legislature, to whom the power of laying and collecting taxes had been previously given, might, in the execution of that power, pass all laws necessary and proper to carry it into effect. I have applied these observations thus particularly in the power of taxation because it is the immediate subject under consideration, and because it is the most important of the authorities proposed to be conferred upon the Union. But the same process will lead us to the same result in relation to all the other powers declared in the Constitution. And it is expressly to execute these powers that the sweeping clause, as it had been affectedly called, authorizes the National Legislature to pass all necessary and proper laws. If there is anything exceptionable, it must be sought for in the specific powers upon which this general declaration is predicated. The declaration itself, though it may be chargeable with tautology and redundancy, is at least perfectly harmless. But suspicion may ask, why then was it introduced? The answer is that it could only have been done for a greater caution, and to guard against all cavilling refinements in those who might hereafter feel a disposition to curtail and evade the legitimate authorities of the Union. The Convention probably foresaw, what it has been a principal aim of these papers to inculcate, that the danger which most threatens our political welfare is that the state governments will finally sap the foundations of the Union, and might therefore think it necessary, in so cardinal a point, to leave nothing to construction. Whatever may have been the inducement to it, the wisdom of the precaution is evident from the cry which has been raised against it, as that very cry betrays a disposition to question the great and essential truth which it is manifestly the object of that provision to declare. But it may be again asked, who is to judge of the necessity and propriety of the laws to be passed for executing the powers of the Union? I answer, first, that this question arises as well and as fully upon the simple grant of those powers as upon the declaratory clause. And I answer, in the second place, that the national government, like every other, must judge in the first instance of the proper exercise of its powers, and its constituents in the last. If the federal government should overpass the just bounds of its authority to make a tyrannical use of its powers, the people, whose creature it is, must appeal to the standard they have formed, and take such measures to redress the injury done to the Constitution as the exigency may suggest and prudence justify. The propriety of a law, in a constitutional light, must always be determined by the nature of the powers upon which it is founded. Suppose, by some forced constructions of its authority, which indeed cannot easily be imagined, the federal legislature should attempt to vary the law of descent in any state. Would it not be evident that, in making such an attempt, it had exceeded its jurisdiction and infringed upon that of the state? Suppose again that upon the pretense of an interference with its revenues, it should undertake to abrogate a land tax imposed by the authority of a state. Would it not be equally evident that this was an invasion of that concurrent jurisdiction in respect to the species of the tax, which its constitution plainly supposes to exist in state governments? If there ever should be a doubt on its head, the credit of it will be entirely due to the reasoners who, in the imprudent zeal of their animosity to the plan of the convention, have labored to envelope it in a cloud calculated to obscure the plainest and simplest truths. But it is said that the laws of the Union are to be the supreme law of the land. But what inference can be drawn from this, or what would they amount to, if they were not to be supreme? It is evident they would amount to nothing. A law, by the very meaning of the term, includes supremacy. It is a rule which those to whom it is prescribed are bound to observe. This results from every political association. If individuals enter into a state of society, the laws of that society must be the supreme regulator of their conduct. If a number of political societies enter into a larger political society, the laws which the latter may enact, pursuant to the powers entrusted to it by its constitution, must necessarily be supreme over those societies and all individuals of whom they are composed. It would otherwise be a mere treaty, dependent on the good faith of the parties, and not a government, which is only another word for political power and supremacy. But it will not follow from this doctrine that acts of the large society which are not pursuant to its constitutional powers, but which are invasions of the residuary authorities of the smaller societies, will become the supreme law of the land. These will be merely acts of usurpation, and will deserve to be treated as such. Hence we perceive that the clause which declares the supremacy of the laws of the Union, like the one we have just before considered, only declares a truth, which flows immediately and necessarily from the institution of a federal government. It will not, I presume, have escaped observation that it expressly confines the supremacy to laws made pursuant to the Constitution, which I mention merely as an instance of caution in the Convention, since that limitation would have been to be understood, though it had not been expressed. Though a law, therefore, laying a tax for the use of the United States would be supreme in its nature, could not legally be opposed or controlled, yet a law for abrogating or preventing the collection of a tax laid by the authority of a state, unless upon imports and exports, would not be the supreme law of the land, but a usurpation of power not granted by the Constitution. As far as an improper accumulation of taxes on the same object might tend to render the collection difficult or precarious, this would be a mutual inconvenience, not arising from a superiority or defect of power on either side, but from an injudicious exercise of power, by one or the other, in a manner equally disadvantageous to both. It is to be hoped and presumed, however, that mutual interest would dictate a concert in this respect which would avoid any material inconvenience. The interference from the whole is, that the individual states would, under the proposed constitution, retain an independent and uncontrollable authority to raise revenue to an extent of which they may stand in need by every kind of taxation, except duties on imports and exports. It will be shown in the next paper that this concurrent jurisdiction, in the article of taxation, was the only admissible substitute for an entire subordination, in respect to this branch of power, of the state authority of that union. Publius. Federalist number 34, the same subject continued, concerning the general power of taxation, from the New York Packet, Friday, January 4th, 1788. To the people of the state of New York. I flatter myself it has been clearly shown in my last number that the particular states, under the proposed Constitution, would have co-equal authority with the Union in the article of revenue, except as to duties on imports. As this leaves open to the states far the greatest part of the resources of the community, there can be no color for the assertion that they would not possess means as abundant as could be desired for the supply of their own wants, independent of all external control. That the field is sufficiently wide will more fully appear when we come to advert to the inconsiderable share of public expenses for which it will fall to the lot of the state governments to provide. To argue upon abstract principles that this coordinate authority cannot exist is to set up supposition and theory against fact and reality. However proper such reasoning might be to show that a thing ought not to exist, they are wholly to be rejected when they are made to use of to prove that it does not exist contrary to the evidence of the fact itself. It is well known in the Roman Empire that the legislative authority, in the last resort, resided for ages in two different political bodies, not as branches of the same legislature, but as distinct and independent legislatures, in each of which an opposite interest prevailed, in one the patrician, in the other the plebeian. Many arguments might have been adduced to prove the unfitness of two such seemingly contradictory authorities, each having power to annul or repeal the acts of the other. But a man would have been regarded as frantic who should have attempted at Rome to disprove their existence. It will be readily understood that I allude to the comitata centuriata and the comitata tributa. The former, in which the people voted by centuries, was so arranged as to give a superiority to the patrician interest, and the latter, in which numbers prevailed, the plebeian interest had an entire predominancy. And yet these two legislatures coexisted for ages, and the Roman Republic attained the utmost height of human greatness. In the case particularly under consideration, there is no such contradiction as appears in the example cited. There is no power on either side to annul the acts of the other, and in practice there is little reason to apprehend any inconvenience, because in short course of time the wants of the states will naturally reduce themselves within a very narrow compass, and in the interim the United States will, in all probability, find it convenient to abstain wholly from those objects to which the particular states would be inclined to resort. To form a more precise judgment of the true merits of this question, it will be well to advert to the proportion between the objects that will require a federal provision in respect to revenue, and those which will require a state provision. We shall discover that the former are altogether unlimited, and that the latter are circumscribed within a very moderate bounds. In pursuing this inquiry, we must bear in mind that we are not to confine our view to the present period, but to look forward to the remote futurity. Constitutions of civil governments are not to be framed upon a calculation of existing exigencies, but upon a combination of these with the probable exigencies of ages, according to the natural and tried course of human affairs. Nothing, therefore, can be more fallacious than to infer the extent of any power proper to be lodged in the national government from an estimate of its immediate necessities. There ought to be a capacity to provide for future contingencies as they may happen, and as these are illimitable in their nature, it is impossible safely to limit that capacity. It is true, perhaps, that a computation might be made with sufficient accuracy to answer the purpose for the quantity of revenue requisite to discharge the subsisting engagements of the Union, and to maintain those establishments which, for some time to come, would suffice in time of peace. But it would be wise, or would it not rather be the extreme of folly, to stop at this point, and to leave the government entrusted with the care of the national defense in a state of absolute incapacity to provide for the protection of the community, against future invasions for the public peace, by foreign war or domestic convulsions. If, on the contrary, we ought to exceed on this point, where can we stop, short of an indefinite power providing for emergencies as they may arise? Though it is easy to assert in general terms the possibility of forming a rational judgment of a due provision against probable dangers, yet we may safely challenge those who make the assertion to bring forward their data, and may affirm that they would be found as vague and uncertain as any that could be produced to establish the probable duration of the world. Observations confined to the mere prospects of internal attacks can deserve no weight, though even these will admit of no satisfactory calculation. But if we mean to be a commercial people, it must form a part of our policy to be able to one day defend that commerce. The support of a navy and of naval wars would involve contingencies that must baffle all efforts of political arithmetic. Admitting that we ought to try the novel and absurd experiment in politics of tying up the hands of government from offensive war founded upon reasons of state, yet certainly we ought not to disable it from guarding the community against the ambition of enmity of other nations. A cloud has been for some time hanging over the European world. If it should break forth into storms, who can assure us that in its progress a part of its fury would not be spent upon us? No reasonable man would hastily pronounce that we are entirely out of its reach. Or if the combustible materials that now seem to be collecting should be dissipated without coming to maturity, or if a flame should be kindled without extending to us, what security can we have that our tranquillity will long remain undisturbed from some other cause or from some other quarter? Let us recollect that peace or war will not always be left to our option, that however moderate or unambitious we may be, we cannot count upon the moderation or hope to extinguish the ambition of others. Who could have imagined, at the conclusion of the last war, that France and Britain, wearied and exhausted as they both were, would so soon have looked with so hostile an impact upon each other? To judge from the history of mankind, we shall be compelled to conclude that the fiery and destructive passions of war reign in the human breast with much more powerful sway than the mild and beneficent sentiments of peace, and that to model our political systems upon speculations of lasting tranquility is to calculate on the weaker springs of human character. What are the chief sources of expense in every government? What has occasioned that enormous accumulation of debts with which several of the European nations are oppressed? The answer plainly is war and rebellions, the support of those institutions which are necessary to guard the body politic against those two most mortal diseases of society. The expenses arising out of those institutions, which are relative to the mere domestic police of a state, to the support of its legislature, executive and judicial departments, with their different appendages, and to the encouragement of agriculture and manufacturers, which will comprehend almost all the objects of state expenditure, are insignificant in comparison with those which relate to the national defense. In the kingdom of Great Britain, where all the ostentatious apparatus of monarchy is to be provided for, not above a 15th part of the annual income of the nation is appropriated for the class of expenses last mentioned. The other 14/15 are absorbed in the payment of interests of debts contracted for carrying out wars in which the country has been engaged, and in the maintenance of fleets and armies. If, on the other hand, it should be observed that the expenses incurred in the prosecution of the ambitious enterprises and vainglorious pursuits of monarchy are not a proper standard by which to judge those which might be necessary in a republic, it ought, on the other hand, to be remarked that there should be as great a disproportion between the profusion and extravagance of a wealthy kingdom in its domestic administration, and the frugality and economy which in that particular become the modest simplicity of republican government. If we balance a proper deduction from one side against that which it is supposed ought to be made from the other, the proportion may still be considered as holding good. But let us advert to the large debt which we have ourselves contracted in a single war, and let us only calculate on a common share of events which disturb the peace of nations, and we shall instantly perceive, without the aid of any elaborate illustration, that there must always be an immense disproportion between the objects of federal and state expenditures. It is true that several of the states separately are encumbered with considerable debts, which are in excrescence of the late war, but this cannot happen again if the proposed system be adopted, and when those debts are discharged, the only call for revenue of any consequence which state governments will continue to experience will be for the mere support of their respective civil list, to which, if we add all contingencies, the total amount in every state ought to fall considerably short of £200,000. In framing a government for posterity as well as ourselves, we sought in those provisions which are designed to be permanent to calculate, not on temporary, but on permanent causes of expense. If this principle be a just one, our attention would be directed to a provision in favor of state governments for an annual sum of about £200,000, while the exigencies of the Union could be susceptible to no limits, even in imagination. In this view of the subject, by what logic can it be maintained that the local governments ought to command, in perpetuity, an exclusive source of revenue, for any sum beyond the extent of £200,000? To extend its power further, an exclusion of the authority of the Union, would be to take the resources of the community out of those hands which stood in need for them for the public welfare, in order to put them into other hands which could have no just or proper occasion for them. Suppose, then, the Convention had been inclined to proceed upon the principle of a repartition of the objects of revenue, between the Union and its members, in proportion to their comparative necessities. What particular fund could have been selected for the use of the states, that would not either have been too much or too little for the present and too much for the future ones? As to the line of separation between external and internal taxes, this would leave to the states, at a rough computation, the command of 2/3 of the resources of the community to defray from a 10th to a 20th part of its expenses, and to the Union 1/3 of the resources of the community to defray from 9/10 to 19/20 of its expenses. If we desert this boundary and content ourselves with leaving the states an exclusive power of taxing houses and lands, there would still be a great disproportion between the means and the end. The possession of 1/3 of the resources of the community to supply, at most, 1/10 of its wants. If any fund could have been selected and appropriated, equal to and not greater than the object, it would have been inadequate to the discharge of the existing debts of the particular states, and would have left them dependent on the Union for a provision for this purpose. The preceding train of observation will justify the position which has been elsewhere laid down, that a concurrent jurisdiction in the article of taxation was the only admissible substitute for entire subordination in respect to this branch of power, of state authority to that of the Union. Any separation of the objects of revenue that could have been fallen upon would have amounted to a sacrifice of the great interests of the Union to the power of the individual states. The Convention thought that concurrent jurisdiction preferable to that subordination, and it is evident that it has at least some merit of reconciling an indefinite constitutional power of taxation in the federal government with an adequate and independent power in the states to provide for their own necessities. There remain a few other lights in which this important subject of taxation will claim a further consideration. Publius.